Welcome once again to the Law Professor channel. In this presentation, we shall be looking at the concept of settlement of property under the Matrimonial Causes Act of Nigeria. Settlement of property under the Matrimonial Causes of Nigeria and Matrimonial Causes Act of Nigeria. And what exactly are we talking about? We are talking about a situation in which parties are before the court for a matrimonial cause, maybe dissolution of marriage, maybe nullity of marriage, for instance. And as we know, if people have been married for some time, they would have shared their lives together, they would have shared their assets, their money, everything together, their entire life. So when the marriage comes to an end, there are some principles, there are some provisions that the law has made to assist the parties to effectively live an independent life. And the law puts into consideration the fact that these parties may, as a result of this matrimonial disputes, maybe dissolution, for instance, may not be equally situated. One may have been disadvantaged by virtue of the fact of marriage because of the way the marital system operates. So the Matrimonial Causes Act of Nigeria makes provision for the courts to make as an ancillary relief what we call settlement of property. So in this presentation, we shall be looking at what this settlement means and how it is granted and what are the various attendant issues that may arise under the law. Now, we'll proceed to share a screen as usual. The law relating to settlement of property, the law relating to settlement of property is exclusive to the Matrimonial Causes Act. It's exclusive in the sense that what we are describing as settlement of property can only be found under the Matrimonial Causes Act. So that tells you that it applies only to statutory marriages. Okay. Now, what do you mean by settlement? Ordinarily, settlement in law involves the conveyance of property or interests in property to provide for one or more beneficiaries, usually members of the settlor's family. Where somebody decides to settle property, he will convey the property or the interest in property for the benefits of usually members of his family. And one of the things that this does is that it tries to, to change what they would ordinarily have received under the statute of descent, under the laws of intestacy, for instance, or what they would not even have received at all, not only changing it, but sometimes even for those who would not have been entitled to any kind of provision under the law. So the said law transfers the property or the interest in property to one or more beneficiaries. But under the Matrimonial Causes Act of Nigeria, the use of the word settlement is unique. And what it does is that, quite unfortunately, the MCA does not define what it means by settlement. But in the light of the provisions of the MCA, we try to sift out what exactly it means. Of course, it also involves the transfer of property or interest in property by one person to the other, under an arrangement that is ordered by the courts in a divorce, in a matrimonial cause. So, but though it is not defined, it is a discretionary order. It's an order that the court has the discretion to issue when it looks at the facts of the case, and of course, that's what is just an equitable circumstances before it. The court may give this. So it is not something that you come to the court and claim as of right. Settlement is a property adjustment order. So it deals with property. It's not about money now, it's about an asset. It's about an asset. And it's available under the MCA as an ancillary relief, as a relief that you get when you are before the court to claim more of the matrimonial causes that we have mentioned, like dissolution of marriage, nullity of marriage, what have you. Unlike maintenance, which we described which is an ancillary, which is a financial order and a financial relief. For assessment of property is about property, asset, physical property, which the court may reallocate for a spouse in a statutory marriage within certain considerations that we shall be looking at. This provision of segment 72 of the provision of MCE regarding settlement of property, we must note before we go into the details, part 4 of the MCE applies to a spouse of a marriage and children of a marriage that is statutory in nature. So we must actually remember our section 69 of the MCA in discussing settlement. That section applies to settlement of property, it applies to maintenance, and it applies to custody of children when there is a matrimonial clause under the Matrimonial Clauses Act. So these provisions related to settlement must be read in the light of who is a child of a statutory marriage, who is a spouse of a statutory marriage. Now, the specific provisions dealing with settlement is 72(1), which states that the court in proceedings under the Act may order the parties to the marriage or either of them to make for the benefit of all or any of the parties to and children of the marriage such a settlement of property to which the parties are or either of them is entitled, whether in possession or reversion, as the court considers just and equitable in the circumstances of the case. So it is as the court considers just when it looks at the facts before it. Each case is taken on a case-by-case basis. Then the court determines whether it wants to order settlement of property in the first place. And the property, in the light of this section, which we should read very well, we bring out the principles and the things that attach to settlement of property. But from here, we can see that it can be made for the benefit of the children of the marriage that is statutory in the light of section 69, and they must be children of the marriage as defined under section 69, and it must be made, it may be made for the benefit of a spouse of the marriage. It could be property that is person is entitled to presently or in reversion. Now, so types of property to be settled. It can be property that one spouse owns. For instance, the husband is the owner of that property, or the wife is the exclusive owner of that property. You can order him to settle it for the benefit of the divorced wife. It could be joint property that they hold together. It is their joint names, their joint assets, and court says should change the interest into the benefit of the other spouse. It might be that you have the property with you now, or it is in reversion. Maybe it has been let out to tenants, such that what would happen is that you are not going to send the tenants away, but the tenancy, the rent would now accrue to the person upon whom the property is settled. So in possession means that you are physically you are in law in possession of that property, or you have a reversionary interest. That is, when the interest of the current person in possession expires, you are entitled to the reversion of the property. Then the property or the assessment of that may be based on a postnuptial or antenuptial settlement. Perhaps they have been entered into a settlement agreement which court is at liberty, not compelled to accept. And you can say in that regard that says that in proceedings under the Matrimonial Clauses Act, the court may make sure other as it considers just and equitable with respect to the application again for the benefit of all of parties and children of the marriage of the whole or part of the property dealt with by antenuptial or postnuptial settlement on the parties of the marriage or dealt with. So the antenuptial or postnuptial settlements are recognized under the MCA, and the court order may affect a property that is already subject to that kind of arrangement. The beneficiary, when it comes to a child, 773 of the MCA provides that the settlement order shall not be exercised for the benefit of the child who has attained the age of 21 years, unless the court is of the opinion that there are special circumstances that justify the making of the order for the benefit of such a child. So the law, the basis of arriving at 21 is not clear. You know that, but perhaps maybe when the MCA was made, it was expected that by the time a person is 21 years, they would have been able to stand on their own, maybe be working or earning a living. But then the situations in the country today, 21-year-olds are not necessarily out of school and are ready to work. So in such circumstances, God may say, well, the child is 21, but you should still continue to pay, make a settlement order for the benefit of that child, maybe till the child is out of school, or a child that is handicapped or disabled in any way. So in any case, general rule is that once the child is 21 years at the date of the order, you cannot apply for a settlement order or make a settlement order for the benefit of that child. When the court is effecting a settlement order, it may order that it's not just going to say we are transfer the property to the person, but it might order the husband, for instance. I'm using the husband most of the time as the person that is doing the settling, that is the settlor, because from the practice from that of family law, it has been observed that most of the times it's women that apply for maintenance, that apply for settlement of property. So that's why I tend to use the husband as person settling property for the benefit of the wife. The court might order the husband therefore to execute title instruments that will ensure that the order is effectively carried out. Well, therefore, either party to the marriage, the husband can apply for settlement, the wife can apply for settlement for benefit of himself or the child of the marriage. So let us get that point straight. But what we are saying is that whoever is the person that is settling property, the settlor, the court may order that they effect every necessary title instrument that would make the order effective. And the court also order that the person provides security for the performance of that order. If it is settlement for the benefit of children, for instance, of the marriage, the court would appoint trustees who would act in the interest of the child so that the property will be utilized for the benefit of the child. And the court would also make a permanent order of settlement. It may order settlement pending disposal of proceedings, or it may order settlement for a visitor. The court is at liberty to look at the facts of the case and determine the context in which it would order settlement and the provisions and the conditions that will be attendant to that settlement order. Don't forget what we've said again. That order given for the benefit of a husband or a wife of a statutory marriage. Either party could actually apply for settlement. The court order of settlement, just like we talked about under maintenance, also in settlement, the same provisions of Section 3 will be applied to settlement. The court will discharge the order if the person remarries, for instance, or if there's any just cause to discharge the order and the property will revert to the original owner. It will modify the order based on changed circumstances of life. It could suspend it and it could revive it. The order that he has suspended, maybe for one reason or the other, it could also revive the order. Because the settlement order is an interlocutory order, just like we said concerning, just like a maintenance order. The settlement order is an interlocutory order. So you could always come back to court and ask for the necessary adjustments to be made to the initial court order. And the court can also compel can ensure that this order is carried out where someone does not execute necessary deed of transfer by using an officer of the court to do the necessary things. In this case, we see Section 74 of the MCA. In the case application, there are many cases. In fact, in practice, when you're having a case for dissolution of marriage or not of marriage, these applications for maintenance, for settlement of property or custody of children are usually applied for. They are not exclusive of each other. And in the cases that the person is applying for maintenance, they apply for settlement of property, they may apply for custody of children, they are children of the union. So you have Akimponi and Akiponi, where the court order settlement for the benefit of the wife and children subject to their behavior. Akimbuwa and Akimbuwa, where the court emphasized that it look at what is fair and equitable, remembering what we said about the statutory provisions based on the evidence adduced by the parties, and Menakaya and Ankaya, where the court actually did not order settlement because despite that the husband had 6 properties. And that tells us that as a practitioner, you must take care of the interest of your client. Because if you don't apply for settlement, for instance, the court is not going to give it to you. It's only what you pray for that the court is going to give. Okay? And the court will look at the facts of the case. And the fact that the man had 6 properties does not necessarily mean that the court will order settlement. Because settlement and maintenance and needs assessment provisions, they are not a trophy that you get out of marriage. there are things that are given to a spouse who needs it. If there's evidence that both parties are doing well, they're financially okay, they are economically okay, and the court does not feel the need for a settlement order, the court will not grant settlement order. Then you have Kafi and Kafi, where the court looked at that when the house was being built, the wife contributed, she was paying for bricklayers, she was buying sand, she was doing this, and she contributed to the life of the husband in terms of the business that he was running. The court ordered settlement for the benefit or of the wife in the lifetime of the respondent. And this, you must be careful. The provisions of the Matrimonial Causes Act says what is just and equitable. In what is just and equitable does not necessarily mean that the spouse should have contributed to that particular property by paying for that property, by assisting the other to build it. When the court looks at the facts of the case, the length of the marriage, the conditions under which they have operated, the court might see this person needs some financial stability. So since the marriage has ended, assuming, imagine a wife who has a housewife. She's educated, but she has not worked during the marriage. She has done nothing but take care of 3 children of the marriage, and she has been under the support of the husband. Now the husband and wife are going apart. She doesn't even have a roof over her head. She doesn't have a job. She's not going to start searching for a job. Maybe the children are even young, and the court has given custody to her because the court felt that she's entitled. She better prepared for custody. In that context, the court might have to order settlement of the property if the husband has, or if the couple have any property, so that she will be secured in starting another life. There's a need to compare settlement provisions and other provisions that the court gives as an ancillary relief. And when we look at settlements under the Matrimonial Causes Act and division of property under the Married Property Act, we could say that both settlement of property and division of property under the Married Property Act or the Married Property laws of various states in Nigeria are property awards. They deal with court orders regarding property assets. But money is also be involved when it comes to division of property. Now, settlement is regulated by the Matrimonial Causes Act as an ancillary relief. Okay, while division of property is regulated under Section 17 of the Married Property Act, it is a procedural section which is meant to determine property disputes during or after marriage. During or after marriage. Settlement does not require spousal contribution to the property that is being settled. The court does not need to find out that, oh, you paid some money when the house was built, or you contributed. It is based on the needs of the parties. It's a discretionary award. Whereas in division of property, what the spouse is coming before the court to say is that, look, this property, I have a beneficial interest in it. In other words, beneficial interest, beneficial ownership imports the legal title, the legal description of someone that is an owner of the property, is the owner of the property. So in division of property, you are claiming that this property belongs to me. You are not saying that the court should do justice, the court should help me, the court should be kind to me, the court should assist me to start out in life. Please help me. No, you're not pleading. You're not asking the court to come and help you. Here you are claiming in a division of property claim a right to the property as of, according to law, that you are the owner of that property or you are a joint owner of the property. So that is one major distinction between them. Then settlement can be in favor of a child of a marriage, while division of property is actually a dispute between the husband and wife as to the ownership of a property. When it comes to settlement and maintenance, you can say that both settlement and maintenance are found under Part 4 of the Matrimonial Causes Act. They are governed by the MCA. The same conditions actually apply to maintenance and to settlement of property. For example, Section 73, which talks about courts order that can vary, that can discharge, that can limit, and then for its benefit.